All right, so welcome to the 2021 Fair Housing webinars. We're going to talk a little bit about current events, some of the intermediate issues that come up. Hopefully, a lot of folks have attended some fair housing training in the past. If you haven't, we'll try and make sure you have information on how to catch up if you need kind of the basics. And in fact, we'll go ahead and start off the session here with our first poll. I've got 3 polls. We're going to start one right now. So check out your screen, and you've got we'll take about 10 or 15 seconds, and just go ahead and let us know if you've already watched that Fair Housing Basics training from Christina Miller. Looks like 40%-ish have seen it. And I highly recommend that one. That's actually out of 2 fair housing videos on YouTube. I believe that one has the 2nd highest view count in the alpha quadrant. It's a very popular one. So check that out. She really covers all the bases. Okay, we're gonna wrap this up here. Everybody's voted. And we got it. So it looks like 37% have seen that video and 63 have not. Share the results there. So those of you who haven't, if you're interested in some fair housing basics, I would recommend checking it out. Okay, let's go back to this. So I'm going to go ahead and start going through this real quickly, and then we'll make some time for Eric. I just want to put out the acknowledgement and disclaimer here. We have been funded through a grant from the Department of Housing and Urban Development, and this is the official disclaimer. Thanks for being here today. And just the housekeeping items here, please use the chat feature to enter your questions. Keep yourself muted to avoid distractions. If you need a certificate, you can email Christina, and keep your tray table and seat back in their upright position. The other thing I want to kind of note is that fair housing, a lot of people just think of it as a civil rights issue, which it is. It's a civil right, it's a human right. It's also an economic development tool. So if everyone has a chance to live near decent education and employment options, people have a better chance to be more productive and develop social networks that help them succeed and be less dependent on social programs. So it works out for everybody. And just to reinforce that, this is an interesting quote from a recent interview with this guy, Jim Tankersley, and he's an expert on the middle class and the economy in the U.S. Once again, and all this is going to be uploaded to the fairhousingforum.org page. We'll have a link to that a little bit later. And if you haven't visited fairhousingforum.org, it's a great resource for housing providers, advocates, just about anybody who is affected by the Fair Housing Act, which is pretty much all of us. What is it? It's the right of all people to be free from discrimination in the rental, sale, or financing of housing. And you can see what's at stake there. So there are 3 associated laws that sometimes intersect with property. One is the Fair Housing Act. That's the primary federal law that you're going to be dealing with. Section 504, the Rehabilitation Act, is going to impact you if you have any federal funding in your property or programs. And then the ADA covers public areas and areas of public accommodation. And again, there are protected classes. I think you probably already all know those. And then this is our slide with lots of links. I invite you to check some of these out. We've got print materials. If you work for a complex that has a number of units, or you're distributed across a region or a community, we'd invite you to request those materials, and you can send those out and distribute them from your property. Check out the English language and Spanish language videos. And again, there's the fairhousingforum.org and idahohousing.com. We also have a fair housing page. We're trying to put resources up there for you to review and download, and then links to lots of different resources online. Okay, so today we're going to hear from Eric Stephen. And without further ado, oh, and thanks again to Christina. I'm going to switch over to Eric's slideshow here. All right, and this was put together with help from David Penny. Today's speaker is just going to be Eric Stephen. All right, Eric, take it away.
Thank you very much, Eric Kingston. As Eric mentioned, Dave Penny did provide substantial input into these materials. We've worked together on some of the other presentations we've done for IHFA previously. So I am Eric Stephen. I'm an attorney in Spokane, Washington. I practice in every county east of the Cascade Mountains in Washington and northern Idaho. My practice is focused on representing landlords exclusively. I don't represent tenants. I essentially perform evictions, I write policy, and I defend landlords charged with housing discrimination. Big focus of my practice is affordable and subsidized housing, as well as manufactured housing communities, mobile home parks. I am going to Ada County to practice here in the future, so I will be representing affordable housing providers in Ada County and Boise area in fair housing complaints, and also in evictions or policy matters related to tenants and subsidized and affordable housing. We're going to talk about a number of concepts today and topics that are related to fair housing. We're going to, let's go to the next slide. We're going to talk about an overview of concepts and protected classes. We're going to talk about advertising. We're going to talk about tenant screening. We're going to talk about developing non-discriminatory rules, enforcing rules in a non-discriminatory manner, and protecting against discrimination claims, and also dealing with discovered discrimination. So lots to talk about. Let's go 2 slides. Next. So fair housing laws come from the feds, come from the state, come from your local governments, and they all prohibit housing discrimination. The law starts with just some generic "thou shall not discriminate in housing," and then we look to the cases and the case law coming out of our courts to provide precedent and to interpret what the fair housing laws substantively mean. It's illegal to treat a person differently in housing transaction because of a person's protected class status. Eric Kingston rifled off a number of different protected class statuses earlier, and I will echo those class statuses, as well as talk about some additional class statuses as we go on. Fair housing laws, next slide. You need to make fair housing laws a priority because it's the law, because if you don't comply with the fair housing laws, you're actually denying people civil rights, and they're going to have recourse through HUD or the Human Rights Commission, or possibly on their own in a private lawsuit. And non-compliance is expensive. It's one of these things where ounce of prevention is worth the pound of cure. A lot of this stuff is not that hard to do. And a lot of it is just conceptually oriented, and we just have to make sure that our staff members and coworkers embrace those concepts of inclusion and get past some of the baggage that they may have brought into their jobs. So let's go to the next slide. Discriminatory actions can be found in refusing to rent, refusing to sell, and finance or denial of housing. So lots of different ways to get in here. You can also get into it through refusing to give information about a unit, discouraging somebody from renting, or lying about the availability of a unit, applying different rules to different individuals. That's disparate treatment. Providing different privileges or standards or qualifications to different individuals based on their protected class status. That's disparate treatment. That's one of the concepts of housing discrimination. Evictions or providing services or failing to provide services, or making discriminatory statements, spoken or published discriminatory statements. We'll talk about all this in a lot more detail as we go on. Next slide. Steering to certain housing, harassing, intimidating, or threatening or coercing individuals because of their protected class status, refusing to rent to a person with a disability, or refusing to let a person with a disability make a modification as necessary for their dwelling to be used as they would be able to use it if they didn't otherwise have the disability. That's a reasonable modification we'll talk about in greater detail as we go on. And refusal to make reasonable changes in your rules, policies, practices, or procedures so that a person with a disability can have equal use of the dwelling. And that's reasonable accommodations. We'll talk about those at length as we go. Let's go to the next slide. The Fair Housing Act protects individuals in all housing. As Eric Kingston alluded to, there are different protections for tenants. The Fair Housing Act applies to all different housing situations. And we get Section 504 of the Rehabilitation Act that relates to publicly funded housing. And then we get to the ADA, the American with Disabilities Act, that relates to places of public accommodation and people with disabilities working through those places of public accommodation. So if you're getting sued for housing discrimination, there's a chance you may get hit with claims under one of or more of these different acts that provide tenant protections. And when I talk about this stuff, I don't want you to be too anxious about it. I just want you to learn what the issues are, try to understand the concepts behind the issues, and try to be able to recognize when these issues surface later on in your housing affairs so that you can reach out to professionals either in your human resource departments or to your council of your choosing to navigate through the issues that are presented. And going along with that, a lot of the stuff we're talking about today, folks, these are concepts that I'm going to be talking to you about and theories in the law. I will answer questions as we go. Understand that for you to be taking a lawyer's advice, you really need the lawyer to review all your relevant documentation and documents that are specifically related to whatever situation you're dealing with. So the advice I'm giving you is base advice without seeing any of your individualized documents. And I want to make sure that you take any advice with a grain of salt and run that through your own in-house counsel who is privy to all your specific facts of your situations and documents related to your situations. Let's go to the next slide, please, Eric. So disabled tenants, applicants with disabilities cannot be asked questions about their disabilities. They can only be asked the same question of all applicants. I think you can ask, are you a person that suffers a disability? You can't ask about the nature or extent of the disability. Any information an applicant with a disability gives their landlord about their disability should be kept confidential. Think in terms of like HIPAA, and that you want to guard and protect this information and have it safeguarded. You don't want to leave tenant healthcare information out for public view or without adequate protection and safeguarding in your files. Some tenants with disabilities may have special needs and require a reasonable accommodation or reasonable modification. We alluded to that earlier. Reasonable accommodation is a change in your rules or policies necessary to allow a person with a disability to live as they would otherwise live without the disability. Reasonable modifications are changes in a dwelling structure or pertinent attribute of the structure to allow the person to live as they would otherwise be able to live but for their disability. We'll talk about both those concepts in further detail as we go on. The next slide talks about familial status. And familial status means having a child under age 18 in the household, whether living with a parent, legal custodian, or a designee. Covers a woman who's pregnant and people in the process of adopting or gaining custody of a child. What action does the law prohibit? That's the next slide. No one may deny housing, limit access to housing, discourage home seekers, or create different rules, fees, or standards because of familial status of the household. This includes rentals, purchases, lending, advertising, and other transactions within the housing industry. Next slide. Familial status does not mean that the landlord has to rent to any household with children. You can still screen for legitimate criteria, objective criteria. I would expect landlords to always be screening for credit history, past rental history, and criminal conviction history. There's some safeguards on those screening that we need to talk about as we go along, and we'll do so as we get further into the materials. The next slide talks about, can a landlord decide which units are better for families with children? And the answer is no. Designating specific units for children, families with children is called steering, and it's illegal. Landlords should give applicants objective information about what is available and let applicants decide what unit is best suitable for their household. We had a situation in Spokane, Washington years and years ago where a prominent developer was sued for housing discrimination because one of their agents told a family with children that they might be better off on a ground floor unit because the agent was afraid that the children might slip through the railing. And the advice that I have for you is that all of your units need to be free from defects. They need to be safe and habitable units that are free from both latent or patent defects, hidden or obvious defects. So it's not up to you to decide what units are better for the family with children. It's up for you to provide a safe dwelling and then let the family decide what unit they prefer. I had a question here from Mike Mowden that just popped up that said, can a landlord decide not to rent to a family because the dwelling would be better suited with a smaller family with, I believe, less load on the systems of the dwelling? And that's a great question, and it's an occupancy restriction question we're going to get into as we go along. There was a case in 1995 called PAF the United States of America versus PAF, and it was an occupancy case where it went all the way up to the United States Supreme Court. And in the PAF decision, the tenants were arguing that the landlord's occupancy restriction was unreasonable and constituted a fair housing violation based on familial status or ethnicity. I can't recall for sure. But the Supreme Court came back and actually pounded the HUD and the complainant in that case and essentially said, how dare you have these generic laws, thou shall not discriminate, and then walk around without explaining how those rules and laws apply and hammering well-intentioned tenants or landlords that were trying to navigate those laws. So in the PAF case, the court decided that the occupancy restriction presented by the landlord was reasonable based on the excessive load that the number of occupants would pose on the systems for that property. There's a thing called the Uniform Building Code out there, or an international building code. And then many counties have fire and safety codes that address occupancy standards. The occupancy standard cases are very difficult for HUD and the Human Rights Commission investigators, and they typically defer to what's called the Keating Memo. And the Keating Memo is a theory that came along about 15 years ago, I would say, probably 25 years ago maybe, from a guy by the name of Keating in HUD. And it was an internal document that espoused a occupancy standard of 2 per bedroom plus 1 as a legitimate sort of generic occupancy standard. Now, about 5 or 6 years ago, Keating wrote a memo, another follow-up memo that said, hey, my initial memo was just supposed to be an internal document, wasn't supposed to be the law of the land. It's been used for more than it was intended to be used for. So I haven't seen a lot of departure from the Keating memo, but I can tell you that there is room to kind of look at the systems and the equipment for the dwelling that's at use or relevant to the situation, and see are the number of occupants presented too much of a load. And I think you really need to have some expert witness testimony on these issues by means of your vendors or people that are familiar with those systems to talk about what the systems can sustain or can't sustain. So be careful with that. Occupancy standards and occupancy cases are really tough for all the lawyers involved, and not fun cases for the investigators too, I can tell you that much. Let's go to the next slide. When renting to families with children, beware that occupancy standards can be different for children than adults. HUD sometimes treats very young children as like 1/2 and not a full adult. And they view that some very young minor children will be sleeping with parents frequently and not count as a child. The slide says landlords can't require children of different genders to have separate bedrooms. We've already talked about the Keating memo. One of the trends that I'm seeing in housing law relating to gender is intimate space relationship situations. And there's a developed breed of housing that intimate shared relationships. I see a lot of it student housing in college towns where the management company is putting multiple tenants in one apartment. Each tenant gets their own bedroom. They share a bathroom. They share a kitchen and a living room. I don't really favor those situations a whole lot because they create common areas for the landlord to administer. I think the way the lease has to be drawn up is that there's a lease of the specific bedroom plus an indivisible share of the other aspects, the common areas of that unit, to make that fly without the landlord having the duty to maintain common areas. So that can be a little bit of a problem. And in those intimate space relationship, shared space relationship cases, the tenants get to pick what gender of a co-tenant that they are going to share space with in some of those situations. I've had some tough ones. I've had a situation recently where a transgender individual was housing with two cisgender females, and the cisgender females have vacated, and the transgender female is still there. It's raised a lot of fair housing issues and concerns we're having to navigate through. And I can only tell you that when tenants are the ones that are making the decision of who's coming in, then they can be a little more selective in the gender of the person that's going to share space with them. And the lead case on this is the roommates.com case that addresses intimate shared space relationships. It's going to be an area of the law we see a lot more development in the next 5 years is my guess. But just know it's kind of a sensitive subject. Next slide. Can a landlord discriminate against people who do not speak English? The slide says no. Typically, there's no requirement for a private market landlord to provide translation services. Subsidized housing providers with a significant concentration of a specific national origin in proportion to their tenant population may be required to implement a language assessment plan referred to as LAP, or a language English proficiency policy, LEP, that helps either translate documents or provide interpreter services. And I'm looking at a number of different counties that I work in where those duties are on the landlord because the significant percentage of a national origin that doesn't speak English as their first language being in a part of the populace there. So I think that's probably 5 to 15%. You get over those thresholds, you're probably looking at some interpretation or translation services, and at least trying to figure out those individuals in your housing that don't speak English as a primary language and providing some assistance to them. And that's going to be especially true in your subsidized and affordable housing. So next slide talks about domestic violence victims and the potential to discriminate against domestic violence victims through your through your zero tolerance of violence policies. It talks about sex discrimination in housing as being illegal, and that when your policy says we have a no tolerance to violence, and if that policy is applied to the victims as well as perpetrators of domestic violence, then that may lead to a claim of discrimination based on sex. So be very careful about that. The slide says women are far more likely to be victims of domestic violence and not the perpetrators. As a result, zero tolerance policies may negatively affect women far more than men. This is kind of a good segue to talk about the two different types of discrimination that we see. One is disparate treatment, which is treating people of protected class status differently based on their protected class status than others. That's just an affirmative disparate treatment. It's affirmative action. It's treating somebody different than somebody else just because they're protected class status. The other type of discrimination is called disparate treatment. Disparate treatment has been alive and well in our appellate federal courts for years, 25 years plus, courts looking at disparate treatment cases. Just 2 years ago, our United States Supreme Court adopted disparate treatment as a theory of recovery in housing and civil rights cases. And what disparate treatment is that you have a facially neutral rule that within its application has a more profound impact on people, a disparate impact on people due to their protected class status. We'll talk about that a little bit more and some of the other concepts that we have going forward. Let's go to the next slide there, Eric.
Okay, Eric, we've got a quick question on
Sure.
domestic violence. Is there any recourse if a domestic violence victim violates the terms of protection order by giving the perpetrator a key or allowing them to come back?
That's a great question. I think there is. I think you got to be really, really careful in how you approach those types of situations. I think the first thing that I'm going to recommend in those situations is call law enforcement, because whether the perpetrator has been permitted to go to the property or not, they will still be arrested if there's no contact or a restraining order out there. So I think the first order of business is to call the police. I think the second order of business is to figure out whether or not the purported victim is bringing this person back in to the household consensually, and you have to work through that. You know, one of the things you're going to be up against in those situations is the advocates for the tenant are all going to be arguing that domestic violence is a cycle and that the victim is unable to prevent the perpetrator from reentry. So it's not quite as easy as it appears at first blush to say, oh, well, you just welcome the guy back, or the perpetrator back in the household, so now you both must go. You may have to really work at it to get more evidence of what's really going on. They're tough cases. They really are tough cases. It's not one size shoe fits all in these scenarios. You're really going to have to flush out the facts. It can be used against the victim at times if they are bringing this person back into the property, but it's not as easy as it looks like at first blush. The next slide talks about penalties that landlords face for violating fair housing laws. Fines up to 50 grand. Ignorance of the law is not a defense. In addition to the fines that you get to pay, you also get to pay your lawyer for defending. You get to pay the state's lawyer and potentially the tenant's lawyer, or the Fed's lawyer and the tenant's lawyer. They can be two different lawyers. If they have a viable claim against you in a cause finding, or they HUD or the Human Rights Commission prevail at trial, they're going to get attorney fees and costs against you. And frequently the attorney fees and costs are sizable. They outweigh the penalties. That's the real stinger in these things. Landlords are responsible for familiarizing themselves with fair housing laws. I get a kick. I do a lot of fair housing training, not only with IHFA, but also with Intermountain Fair Housing Council out of Boise, also with Northwest Fair Housing Alliance, HUD, and Human Rights Commission out of Washington. And I never fail to hear people say that they have already had fair housing training and don't need it. And I think if you were to ask Dave Penny or myself or Eric Kingston about how comfortable we are with fair housing law, I think all three of us would tell you we're not that comfortable with it, that it's in a state of flux and it's constantly shifting. I like to jokingly tell my staff and others that practicing laws like walking your pet cobra, don't turn your back on it because it's going to bite you in the butt. And you've never had enough fair housing training. I haven't had enough fair housing training. David Penny and Eric Kingston haven't had enough fair housing training. I don't think any of us are so bold as to say we don't have new information and new concepts to learn, and that the laws are in a state of flux. And some of the things that I've taken as a given, I find later on that they've been challenged. Those concepts have been challenged, are no longer accurate. I can give you an example, and I don't want any questions on this because we'll get into it more as we go. But, years ago, I had the impression that a person with a disability could only have one assistance animal or service animal for that disability. And now through 30 years of practice, I've come to find out that's not a safe theory to embrace, and that there are situations where a tenant can have multiple animals for the same disability. Not something I want to hear as a landlord advocate, or you want to hear as a landlord or a manager, but it is what I believe the law of the land is today. And as I said, the law of the land is shifting all the time, guys. Several months ago, I would have expected Dave Penny and Eric Kingston to tell you that sexual orientation and sexual gender identity weren't necessarily laws that we had to worry about in Idaho. And then HUD gives out what's called the Warden memo that Eric Kingston referred me to, and we find out that, lo and behold, gender identity and gender orientation or sexual orientation are now protected classes by HUD. So this stuff can happen overnight. You know, I've been trying to get everybody in Idaho to be sensitive to source of income discrimination. I'll talk about that as we go on. But these theories of recovery can come to you very quickly, and they don't have to be passed through a legislative process. Every year I watch the Washington legislature fail to enact certain laws that I don't even think are necessary. And people, that was the source of income for a long time. And then I think there could have been claims on that a long time ago, but they weren't forthcoming. So landlords are responsible for familiarizing themselves with fair housing laws, and you really need to stay up on them. You need to be doing fair housing training annually, folks, if not at a more recurring timeline. Landlords can select tenants on the basis of their ability to pay rent on time, their ability to take care of the rental property, and their ability to respect rights of neighbors. And I would add to that, the Landlord-Tenant Act excludes people that constitute a direct and immediate threat to property or others, but you have a duty to mitigate those threats. So you can't just say, hey, I don't think you're a good fit here because you constitute a risk. You may have to mitigate those risks at times. Let's talk about advertising and marketing. And the Fair Housing Act makes it illegal at section 3604C to make, print, or publish, or cause to be made, printed, or published any statement or advertising with respect to the sale or rental of a dwelling that indicates a preference or a limitation or discrimination based on race, color, religion, sex, handicap status, familial status, or national origin, or intention to make such preference, limitation, or discrimination. If it's found that an advertisement is published with discriminatory language, the person who published it and the agency that placed the advertisement are both liable, as is the publisher. Generally, a housing advertisement should describe the property itself and not the potential occupant. And this is a concept that Dave Penny and I both embrace very wholeheartedly. It's all about the property, and don't sell to the people, sell to the property. So the next slide talks about some of the specific examples of problematic advertising. Advertising that uses certain words, phrases, pictures, or other visual representations can be discriminatory. So if you have a photograph in your ad that has all people of Caucasian race, that might get you in hot water for race discrimination. Or if you had all people one specific ethnicity, even if it's Hispanic or some other ethnicity besides Caucasian, if you have all people of one type of ethnicity or race, your advertising may be determined to be discriminatory. Certain types of media as a means of discrimination. So if you advertise exclusively in a media that is directed towards a protected class or group and isn't seen by other protected classes or groups, then you may be accused of discrimination. So if you were to take out an ad that was in Ebony or something like that and not advertise in any other media, then you may be alleged to be discriminating. There are certain code words, catchwords, and catchphrases that have been determined to be discriminatory. Use of color words such as housing for white people or black people would obviously be discriminatory. Familial status, advertising that families are not welcome. That would be a problem. If you advertise for married couples only, that would be a problem. I had a case years ago with some student housing that had a slogan or a banner put up in front that said, "Perfect for singles." and they got sued for housing discrimination against familial status or on a familial status basis. Handicap property that's not suited for handicap, so you can't advertise property is not suited for handicap. By contrast, you can, this is one area where you can be inclusive, and you can say ADA accessible unit or handicap disabled accessible units available. National origin, you would get into hot water if you had advertising that expressed a preference to Italian community or Mexican or Hispanic American community. So be careful if you talk about any types of communities. Somebody used to ask about HOPA housing. Well, HOPA housing is one of the areas where you can discriminate against age and you can discriminate against familial status. So in HOPA housing, you can say nobody under age 18. You can say that this is senior housing or housing for older people. The preferred language would be 55 and older housing, 55 and over housing, or 62 plus housing. HOPA housing is the Housing for Older Persons Act. So that's HOPA housing. But HOPA housing is one of the few areas where you can discriminate on the basis of age and familial status. You are told not to use words like adult community in HOPA housing. They want you to say senior communities, and I would suggest that you use the actual act words, which are 55 and older or 62 plus. Be careful with religious or race discrimination in housing. I talked earlier about national origin, Italian community, Hispanic community. Similarly, if you were to say we have a preference for Asian community or Asian community members, that would be a problem with respect to race, or Hispanic community members welcome, problem with respect to race. If you offer this to one ethnicity or race, you are by sort of negative inference not offering it to other race or ethnic communities. So be careful with that type of preference. Religion, if you suggested that you were a religious Catholic community or Christians welcome, that would get you into hot water. And sex and gender identity, can't advertise for a specific gender except for the roommate's situation with intimate shared relationships. Next slide is more the same type of situations.
Eric, we got a quick question I just want to touch on. And somebody was asking, is there an answer to this question? What about multiple companion animals for the same disability?
Well, we're going to talk about that as we go on. I don't want to entertain the question right now.
Okay, all right.
That's going to be factually driven. It's going to be whether or not the healthcare or the third-party provider is recommending that there's a need for multiple animals for the same disability. But we can talk about that when we talk about FHEO 2020-01 and reasonable accommodations. So,
okay, and I did put a link to HUD's HOPA page in the chat, so if people want to read up on that.
That, and we should also put up a link to the FHEO 2020-01 HUD guidance on reasonable accommodations relative to service and assistance animals. So that'd be another good link. Next slide, talking about other areas of discriminatory advertising, photos, drawings, or symbols that imply a preference with respect to any of the protected classes. If you put a cross in your advertising, that's going to sort of express a preference for Christianity. If you put a Star of David, that might have a preference for people of Jewish faith. So just be careful with your symbols and stuff, photos and drawings. Describing the location by using potentially biased references. You wouldn't want to say apartment complex near synagogue or apartment complex near Catholic church. Those are loaded statements that might get you into discriminatory liability relative to your advertising. Referencing discriminatory facilities that are close to your apartment complex or your housing might be problematic. If you were to say that the apartment complex or the housing is near XYZ country club, and that country club's notorious for servicing the Ku Klux Klan or something along those lines, then that discriminatory facility would be linked to you, and you would be sending sort of a covert message of discrimination in HUD's mind. Avoid using welcoming and inclusive terms such as advertising that states a specific group or welcome. This is kind of an example of what I talked about earlier. Great for Hispanics, great for Jewish people. The limitation on this is you can express preference for HOPA housing, housing for older persons, and I believe you can express a preference for people with disabilities being welcome. Those are about the few. The materials, the slide finishes with saying that you should use the HUD Fair Housing logo and words that that follow and echo the fair housing guidelines, that all groups are welcome and that you do not discriminate on the basis of any protected class status. HUD has forms for that. You should be having those forms in English and then also any other language where you have a high concentration of individuals that speak that other language as their first language. So just some good ways to keep yourself exempt from housing discrimination and advertising. The next slide actually talks about HOPA housing, talks about housing communities for 55 plus, 55 and older. 80% of the units must be occupied by at least one person 55 years and older. There must be an audit every 2 years to determine household composition. And then the complex that is offering the HOPA housing has to, through their conduct, through their advertising, and through their programs, demonstrate an intent to provide housing for older people. And use of the terms adult community is insufficient. Should be using senior housing, 55 and over, or 62 plus. There's a marketing summary in the materials. It says display fair housing posters in your office. Number one, post a fair housing policy. Ensure that advertising is fair housing compliant. Advertise attributes and amenities for the property. Don't advertise who you're looking for in a tenant. Don't steer the property and tell the tenants who is going to be the better or what property is going to be better for the tenants. Let them make those determinations. You just show them the property. And don't make assumptions about what an applicant may want or not want. And you know, this kind of goes right into the hey, this complex doesn't have a playground. You guys got kids. You'd be so much happier down the road. We got another place or another competing management company has another place down the road that has a great playground. Well, that's steering, and we just can't do that, folks. So we gotta be smarter than that and see when those issues arise. So next slide is actually about tenant steering. Let's go. I've already covered that. Next slide. So with respect to, this is tenant screening. Okay, excuse me. With respect to tenant screening, develop written screening criteria. Now, one of the concepts that I want you to champion here is that your written documentation of policy, your written operating agreements, your rental rules, your leases, your house rules, all your different internal policies, you want these policies to be written. You want these policies to be observable and objective and hard and fast. These policies serve you two purposes. They work as a sword for you to enforce the rights that you want to enforce, and they work as a shield to provide you with exculpatory evidence of why you haven't discriminated in housing. And I just the other day, I was working with the company, and it's a HOPA housing provider. And the managing agent says, I don't want to have a waiting list. Waiting lists are way too much of a pain in the butt for me to deal with. I get so many applicants, and waiting lists are just a nightmare. And I was trying to argue to the individual that the waiting lists are actually a great tool for the landlord and for the management company and the owner to avoid discrimination liability, because those waiting lists show that you called the next applicant and stuff that was online. Now, I understand it can get problematic when people don't return calls quickly and you have to kind of wait, and that you want to rent out property and it goes immediately. But these waiting lists are really, really important, especially with respect to unit transfers for people with disabilities, if they make a reasonable accommodation request. So it's all about your documentation. And when we're talking about tenant screening, you need to post objective screening criteria that tells the applicants what's going to result in acceptance or denial of their application. And that screening criteria should be based on your past rental history, past credit history, past criminal conviction history. And we'll talk about this stuff as we go on, but you want objective screening criteria and you want it to be in writing. It should pertain to, it should be limited by the Fair Credit Reporting Act. The Fair Credit Reporting Act typically says that you can look back 7 years from the tenant screening report to evaluate whether or not conduct constitutes a basis for you to exclude their application. And the Fair Credit Reporting Act at both the federal and the state level talks about either granting the application for credit, which can be a housing application, it's considered a credit application in this context, or conditionally accepting the tenant, which is saying, I'm going to accept you as a tenant, but I'm going to ask for a cosigner or a higher deposit or a higher amount of rent, or a adverse action by means of denial. So you can have an adverse action under the Fair Credit Reporting Act if you conditionally accept an applicant or if you deny the applicant. So if you attach any strings to an application coming in that they wouldn't otherwise have, you've made an adverse action. The Fair Credit Reporting Act requires you to send a written, adverse action notice that tells the tenant, applicant, why they were rejected, what you used to evaluate their application, and tells them that they have a right to obtain a free copy of their credit screening report upon request. So there's some information that needs to be in that adverse action notice, and you need to talk to your screening providers to make sure that either you or the screening company is sending out an adverse action notice. You need to make sure that your screening determinations are based on the Fair Credit Reporting Act limitations in time. You could not deny somebody housing because they had an eviction 20 years ago. That would be a violation of the Fair Credit Reporting Act and could get you into hot water. So HUD guidance memo from April 4th, 2016. Back on April 4th, 2016, HUD released a guidance memo on criminal conviction screening. We're going to talk about that as we go, but essentially it said policies such as no felons, policies such as nobody with a criminal conviction are discriminatory due to disparate treatment, and that those types of policies will create very clear liability for you. So we're going to talk about that in great detail. And then close to my heart, source of income issues. There's a case out of New York out of Yonkers, New York. It's probably a 25, 30-year-old case where a landlord was sued for housing discrimination because they refused to accept a HUD Section 8 housing choice voucher recipient. And the landlord in that case and the landlord's attorney weren't very good. They were actually pretty racist. They made a lot of overtly just obvious discriminatory statements, and their discriminatory animus was obvious. They were terrible people with terrible ideology and policies, but they got sued on disparate impact instead of disparate treatment. Court found liability against them, and I've been telling Dave Penny for a while now, hey, you got to be afraid of source of income liability coming to you from just a case law basis. You don't have to have legislation in your state for somebody to make this case out. It's a disparate treatment case, and it could happen at any time. So I recommend landlords to accept tenants that have vouchers if they otherwise meet their screening criteria. Screening criteria should inform the tenant what will result in denial of the application, and it should be applied uniformly to all applicants. One of the big problems I see in tenant screening is the managers making pre-screening determinations. A lot of people will call you up and say, hey, I want to apply for your housing. I really like your place, but I want to know if I'm wasting my time applying there. I was convicted of bank robbery 8-10 years ago. Is that going to be an impediment for me applying? And if you as a landlord say, hey, yeah, we don't take convicts or felons, then you've got some big problems right there, because your pre-screening determination may be used to say that you are discriminating against people on the basis of race, as I'm going to talk about when we talk about the HUD guidance memo of 2020-01. So don't do that. I want clients to provide tenant applicants with a copy of the screening criteria and with an application to complete, and not tell the applicant whether or not the person's going to either pass or be denied before that application is processed. It's essentially one of those no good deed goes unpunished type of situations. Next slide. Did you want to ask a question now, Eric Kingston?
Let's see. We've got a couple questions here. Let's see. One is just looking for links to an article or book that can read up on fair housing cases and safe phrases. I would say check out that Christina Miller Fair Housing Basics video. That's your first option. And then take a look at fairhousingforum.org. Go to the Intermountain Fair Housing Council page. There are lots of trade associations like the Association of Realtors, property management groups that also have lots of good information, sort of pertain to your particular industry, and I would check those out. We had let's see, one question. What about an employee who asks to pray at business meetings or luncheons? And then another one who wants to know if they can discriminate against people because of their political affiliation. And then what's the best response for somebody who, oh, never mind.
Let's go to the first one. If I had somebody that wanted to pray before meetings, I'd let them pray before meetings, and I wouldn't make anybody else pray before meetings if they didn't want to. If the next question was,
discriminate against people based on religious affiliation.
Political ideology.
I mean, not political affiliation. Yeah.
Yeah. I don't think that's protected right now. It might be protected in Washington. It's not protected in Idaho, as far as I understand. But I err on the side of trying to recognize almost any protected class, because there's so many expansive protections, and they continue to be developed. And the bottom line is, you just got to be sensitive to the issue with respect to your policies. And even though political ideology isn't necessarily a protected class in and of itself, it might work its way into another one of the protected classes based on the facts of your situation. So I'd be concerned about that. And it won't surprise me if it becomes a protected class status down the road, especially after our last administration. So the next slide talks about providing the adverse action notice to conditionally accepted or denied applicants. I've already talked about that. Let's go back. I think you're a slide in front of me, Eric Kingston. Avoid steering. Keep track of and document criminal activity in the area where your leasehold is situated. This will allow you to screen better for criminal activity and criminal conviction history, and I'll explain that when I go through the HUD guidance from 2020-01 here shortly. Establish safeguards relative to the screening process. All my clients' screening processes have little covenants in them that talk about the landlord, managing agent being able to stop screening if the applicant is belligerent or hostile, to not process applications that are incomplete, false, or misleading, and to stop the application process if the applicant is intoxicated or impaired. People that are intoxicated or impaired lack capacity to contract. So I want your landlords to have tools to manage the application process. Establish a review process for denied applications, especially those denied on the basis of criminal conviction history. Keep good records of all inquiries or applications. When you get sued for housing discrimination, you're going to be asked to produce a number of past documents. And if you were sued for housing discrimination in advertising, they may ask you to provide a copy of your screening criteria, provide a copy of all the adverse action notices that you've issued. If you're unable to produce that documentation, there's a negative inference against you. So it's all about the documents, guys. I think David Penny would champion this with me, that we win and lose cases on documents. Years ago, I had a fair housing case that went to a 3-week jury trial. And when I was getting into the case, I was kind of having a panic attack. How am I going to defend this case? How am I going to defend my clients? How am I going to build the case that we're not liable? And it just hit me. Exculpatory evidence. It's all about the documents, Eric. Gather all your documents that tend to prove the allegations aren't accurate. But Landlords win cases with record keeping, whether it be a fair housing case, an eviction case, or whatever. Document, document, document. Your lack of documentation is not going to help you. It's not going to give you any safeguard. Keep good records and inquiries, talked about that. Use third-party screening service for all rental applications and develop a formalized waiting list policy. I think these are things that will help you avoid housing discrimination liability. The next slide asks, can a landlord require a social security number from a prospective tenant on an application? And this is Dave Penny's slide. It says using the social security number as part of a background check on a prospective tenant is considered standard rental policy as long as the landlord requires the social security number from all prospective tenants. If you were to just ask people of color for social security numbers and nobody else, you got a problem. That's disparate treatment. If the landlord is requiring a social security number from tenants only from a particular national origin, that would constitute a fair housing violation, and landlords should consider alternative forms of identification for individuals of foreign national origin. So I want you to be fluid in accepting documents from tenants that help prove their identification. Let's go to the next slide. You can ask for all adults over age 18 to show valid forms of identification. Children under 18 aren't typically required to provide identification unless you ask for that from everybody. If they forgot the ID, the property manager or the authorized agent may ask the tenant to complete a form to include the name and address and any additional questions to confirm the tenant's identity. And then let's go forward another slide. Here's a list of a bunch of alternative forms of identity that you can look at. Driver's license, state photo identity cards issued by the Department of Motor Vehicles or equivalent, U.S. passport card, DHS trusted traveler cards, non-global entry, U.S. military IF, permanent resident cards, DHS designated enhanced driver's license, airline or airport issued ID, if it's issued under TSA approved security plan, federally recognized tribal issued photo ID, HSPD 12 PIV card, foreign government issued passport, Canadian provincial driver's license, Indian or Northern Affairs Canada card, and transportation worker identification credential. Just a list of some other alternative forms of identification if somebody doesn't have a social security card. I mean, I don't even know where my social security card is, folks. So I think you got to be careful with how rigid you are with that. Next statute or slide talks about this is the Fair Credit Reporting Act found at 15 USC 1681. This is the body of federal law that I was referring to earlier that establishes time limitations and how far back you can go in scrutinizing an application. It talks about you can go back 10 years from the consumer report to look at a bankruptcy filing. You can look at civil suits for judgment that are within 7 years old, tax liens that are not more than 7 years old, counts and collection not more than 7 years old, any other adverse item which antedates the report by more than 7 years. Next slide. Criminal conviction history should be addressed in this, and that's not more than 7 years from the release of probation, parole, or confinement. So when you have somebody that is getting out of prison, it's not their conviction date, it's the 7 years from the release of probation. Next slide talks about HUD guidance on criminal conviction records. This is the HUD guidance memo of April 4th, 2016. This is just sort of a sort of introduction into that document. You really, really should read the HUD guidance memo from 2020, HUD guidance memo 2020-01 that relates to criminal conviction screening. It was released on April 4th, 2016. The guidance addresses how discriminatory effects and disparate treatment methods of proof apply in fair housing cases relative to an individual's criminal history. The memo talks about as many as 100 million U.S. adults and nearly 1/3 of our population have a criminal record of some sort. Across the United States, African Americans, Hispanics, and people of color are arrested and convicted and incarcerated at rates that are disproportionate to their share of the general population. HUD guidance goes on to give you a 3-step process to evaluate discriminatory practices relative to criminal conviction screening. And the first step is for the plaintiff, HUD, or the private applicant to say that you have a discriminatory policy as it relates to criminal history screening. And it says that the plaintiff in these cases can actually use national statistical data that shows that people of color are arrested and convicted at disproportionate rates than the rest of the populace. By contrast, if your local data is different than the national data, then your lawyers can offer the local data on how people of color are arrested and what the rates of incarceration are relative to people of color versus Caucasian, to find out if there's a disparate treatment in the practice of criminal conviction screening. So that's one of the first steps is excuse me, can you guys keep going? One of the first steps is to, for the plaintiff, HUD, or the complainant to say that you have a discriminatory practice and screening because you are weighing criminal convictions or arrests in an improper manner. Next slide. The second step is for the housing provider to prove that the protected class or practice is justified and furthers a legitimate, substantial interest of the housing provider. And it says here that the interest proffered by the housing provider may not be hypothetical or speculative. HUD goes on to recognize that protection of other tenants and protection of the property is a legitimate reason for tenant screening, but that the housing provider must prove that its policy or practice actually assists in protecting tenants' safety or the property. And the HUD memo says that bald assertions based on generalizations or stereotypes that any individual with an arrest or conviction poses a greater risk than those without a conviction are not sufficient. So you can't just say that people that are arrested or people that are convicted for crimes constitute a greater risk to your property or to the other neighbors. The materials talk about exclusion based on arrest is not going to meet the HUD burden. It talks about how arrest is not indicative of actually engaging in the criminal activity. So if you have a policy that says I'm going to deny an application because of an arrest, you're likely going to be found to be discriminating on the basis of race with respect to your criminal conviction screening policies or your criminal history policies. Exclusions because of prior convictions. It says in some situations, a prior conviction will serve to prove that an individual engaged in criminal activity. And this is HUD telling you that even a conviction of criminal activity is just evidence they engaged in criminal activity. The housing providers that apply a policy or practice that excludes persons with prior convictions must still prove that such policy or practice is necessary to achieve a substantial, legitimate, non-discriminatory interest. A housing provider that imposes a blanket prohibition on any person with a conviction will be unable to meet this burden. So if you have a policy that says no felons or no convicts welcome, then you're going to fail the this HUD guidance. The housing provider must show that its policy or practice actually distinguishes between criminal conduct that indicates a demonstrable risk to resident safety and property and criminal conduct that does not. So what they're saying here is, as a housing provider, your screening criteria relative to criminal history must distinguish between serious crimes that constitute a direct threat to persons or property versus convictions for crimes that don't constitute a direct threat to person or property. And they don't want you to say, oh, well, I only screen for criminal convictions, but if you have a criminal conviction for driving without a valid operator's license, you're excluded from housing. That won't fly. you need to differentiate in your screening criminal conviction history that constitutes a significant risk to health, safety, or property, and criminal conviction history that does not. And you essentially need to be screening for significant crimes against persons or property as opposed to just all crimes. Policy or practice that fails to consider the nature, severity, recency of criminal conduct is unlikely to be proven necessary to serve a legitimate, substantial, non-discriminatory interest of the provider. Third step, and this is going to answer some of the questions I've seen posed, is for the plaintiff, HUD, or the complainant to allege that the housing provider could have had a more individualized assessment policy that would have avoided the discriminatory effect of their existing policy. So in the third step, the housing provider or the complainant says, hey, you need a more individualized policy. And the materials talk about delaying consideration of criminal history. You can talk about they want you to delay consideration of criminal history, screening criteria until you've assessed the individual's financial history or rental history. I don't think that's accurate. That's kind of a HUD disconnect and not understanding the nature of the industry. We don't really bifurcate the screening process in my experience. There's a statutory exemption in the criminal conviction screening. You can exclude people because of history of manufacturing or distribution of controlled substance. HUD had to carve out that caveat in the liability theory because their own federal subsidized housing programs make an exclusion for people that have manufacturing or distribution charges. The next slide is a sample slide that, next slide. Next slide is a sample slide of a criminal conviction screening policy. And somebody asked about screening against rape and that type of thing. And you'll see here that I have included a list of very serious crimes. I've started the document with a section that the first paragraph addresses the intent. And it says that the landlord and the owner and the management desire to provide a well-maintained and well-kept property for the benefit of all residents. Screening criteria is adopted with the intent of maximizing the ability to provide safe housing for residents, managerial staff, the property, and neighbors. Screening criteria is intended to minimize risks, liability risks, the cost of insurance, maintenance, and repairs. Screening shall be designed to provide housing to individuals who do not constitute or pose an unreasonable risk of direct threat to persons or property, of physical harm, or adverse housing environment. Owner and management agree to limit screening of conviction history to serious offenses against persons or property. Owner and management will screen for criminal convictions for crimes against persons or property. Crimes listed below, as well as substantially similar crimes, may result in denial of the application. Then I list all the different crimes. And this, folks, earlier I talked about how the HUD guidance memo says that you can't screen for hypothetical purposes and that your screening has to be tailored towards your property and towards the individual applicant. Well, your list of criminal activity that you can screen for is really driven by the kind of criminal activity in the vicinity of your property. So if you've seen these types of crimes or other crimes that are very serious crimes against persons or property that aren't in this list, you might add them to the list if those types of crimes have occurred on or near your property. I vetted this document with Zoyan Olson out of Intermountain Fair Housing Council in Boise. I vetted this document with Marley Hawkendonner, the executive director of the Northwest Fair Housing Alliance out of Spokane. Both those ladies had no problem with this document, thought it was a good document. I showed this document to one of the Washington State Attorney General's deputies, assistant attorney generals, and the attorney told me that she was offended by the document and that she would never authorize this document. And I was just at a shock. I asked her why, and she wouldn't tell me. My guess is that she thought some of the conduct that I alleged was not significant enough. And I told her I would love to see her make that argument to any jury in Washington that I was around. And I just started looking at this for my own purposes, trying to figure out what crimes she might have thought weren't serious enough. And I thought lewd conduct. Well, I see that in multifamily housing situations all the time. I think it's a big problem. Identity theft, I think that's a real problem for property rights in multifamily housing complexes. I see dumpster diving situations every now and then where people are digging out other people's bills. Prostitution and pandering, I see those types of problems in multifamily housing, and I think it's a big deal. Malicious mischief, that drives me absolutely crazy. I think it's a big problem in multifamily housing. And reckless burning. Those are the crimes that I think that are soft on this list. I'm offended that anybody would think those are soft crimes because I think they're horrible crimes, and I think they're a real problem, and I'm offended by them. So just know that not everybody shares my view that this is such a great document. That's why it says not for use and it's sample only. The document goes on to talk about matters related to criminal conviction history, circumstances and mitigating factors that may be considered include the nature and severity of past conduct, age of the individual at the time of the conduct, evidence of good tenant history before or after conviction or conduct, evidence of rehabilitation or treatment efforts, restitution of damages, if any, nature and severity of offenses, number of past offenses or lack thereof, and impact of housing decision on other non-offending household members. These are all part of the mitigating circumstances that you should look at if you have a tenant applicant who has a conviction on their record and the conviction actually meets into the serious crimes. So this is just an opportunity for you to kind of come back, reevaluate the situation, ask the applicant if they have any mitigating factors or circumstances that you'd like them to have you evaluate. I had a case right after this came out that I almost thought was a test where I got an applicant, he was denied, and then he had a social worker write a statement that said, I just met George. George is a wonderful man and is going to be an incredible attribute to our society, notwithstanding his criminal conviction history. He had been convicted a couple of times of robbery and burglary. He had one offense that was 6 years old and another offense that was 1.5 to 2 years old, and then a bunch of intermediate offenses for petty theft. And this social worker writes this letter that in the last hour and a half getting to know George, I've determined he's no longer a risk. And I told the client, deny this application. You can deny this application because there isn't evidence of good tenant history before or after the conviction. There's terrible evidence of tenant history. The person's been a thief all their life and they're still a thief and a burglar. And they've been doing it recently. And this social worker has a very limited relationship with this individual to assess that they're no longer a threat. We ended up denying the application. We didn't get any feedback or adverse liability from that or any complaints or anything else. But that's sort of an example of how you have to kind of go through this. It's not enough that the person has a conviction for a serious crime. There has to be a lack of mitigating circumstances and the conviction. I have another covenant in my screening criteria, and this covenant is to protect clients who get that crazy case where the applicant has a pending criminal case for an extremely serious crime. And this is the guy that's out on manslaughter, first degree, or first degree or second degree burglary, and they've been able to bond out. And this covenant may get you into hot water. When the AG told me that she wouldn't champion this document, this may be the covenant she was talking about. I feel like this covenant's necessary because I can't live with this hypothetical any other way. It says applicants with an arrest history, with an arrest and pending criminal case will be evaluated based on the facts of the underlying case to determine if the conduct justifies exclusion as a direct threat to others of the property. If the applicant has a criminal case pending for any crime set forth in the standard criminal addendum, the application will be put on hold until the case has been finalized. The applicant Applicants are not allowed to be approved to move into the leasehold until the criminal case is finalized and determined. Provided management may limit application of the policy to conduct that would justify exclusion due to the threat posed to person or property. So this means that if the criminal case pending is not a serious crime, then you don't apply the policy. If the case is a serious case and you want to try to suspend the determination of the application until you get a disposition on the criminal case, that's what this covenant's designed to allow you to do. FHEO 2020-01 relative to reasonable accommodations for service and assistance animals was proffered by HUD on January 28, 2021, I believe. 2020. That document, folks, talks about delaying determinations of reasonable accommodation until the tenant has an opportunity to provide third-party verification. I think you can make sort of an analogous argument that this delaying the process of the application until adjudication of the criminal case, is somewhat analogous to HUD's guidance in the reasonable accommodation context when third-party verification hasn't been received, which is you do not decide the matter adversely to the applicant or the person requesting the accommodation, but you can delay or suspend the determination until you have all the documentation necessary to make the determination. So that's how I would argue that applicant arrest covenant in my tenant screening criteria. Any questions here, Eric Kingston?
We got one question. Somebody asked about what are your thoughts on those who appeal our denial based on a drug or alcohol related crime and require them to take an online course in drugs and alcohol, or showing proof of any courses they may have taken to include with their appeal?
I think that goes to two things. First, it goes to whether or not they even have a criminal conviction because they're trying to appeal the conviction, it sounds like. Number two, I think it goes to evidence of mitigation. And if somebody was convicted of some sort of crime where drugs or alcohol was a component of the crime, and then was to provide you with evidence of rehabilitation or something, then you would need to consider that in making your determination.
Also, I'm getting a few questions from folks about the presentation being available afterwards. And just to reiterate to everybody all at once, if you're not checking the chat, this is posted, this presentation is posted at fairhousingforum.org under the Spring 2021 training session heading. So it'll be near the top of the posts on that website. So please take a look at that. It's going to have links to this document, and there's lots of other good stuff you can mine in there too.
The next slide.
Okay.
So this is my chicken little call for action on source of income discrimination. In Washington State, Tenants Union had some information on their website, said discrimination against renters based on verifiable and legitimate sources of income is unfair and discriminatory practice. Policies like no Section 8, no vouchers are a pretext for illegal discrimination that have disparate impact on most vulnerable families. Renters who receive verifiable source of legal income, such as Social Security, child support, Social Security disability income, Section 8 vouchers, or any other government subsidy should not be automatically assumed to be unacceptable or undesirable renters. And to get past your source of income discrimination theories, I recommend that any rent to income quantifiers be based on the tenant's proportion of rent. So if you have a criteria in your screening that says applicants must have 3 times the amount of rent, amount of income to rent, you want to couch that in terms of applicants must have 3 times the amount of income to the tenant's portion of rent. So just a little bit of language will provide a safe harbor for you in these types of situations. Also, removing any kind of statements in your advertising that profess that you don't accept voucher recipients would be a good move. And as I said earlier, you don't have to have this be the law of your land for this to be a theory upon which you get sued. And if you had an aggressive tenant advocate that wanted to argue that source of income discrimination was a theory of recovery based on disparate treatment, they could make that case in Idaho, I believe. So I would be concerned about this, folks, going forward. Think in terms of inclusion and not exclusion. So just a word for the wise there. Let's go to the next slide. Keep going here. Next slide, develop non-discriminatory rules. Provide core set of rules, basic rules to all tenants. Post the rules in the office. Go over leases and rules with your applicants, especially your rules when the applicants are coming in and doing the lease up process. You are doing yourself no favors by just handing the tenant a 40 or 50 page lease and expecting them to read it and understand it. Go over the rules. Stress that you're a great community and that you expect all the tenants to play by the rules and that you want to do your job as the landlord as long as they do their job as the tenant. And set the parameters and the expectations of the relationship early on. Set rules that set limits may be reasonable if they are based on realistic, not exaggerated health or safety concerns. Rules should address behavior, not status. I always say address conduct, not character. Should not be so restrictive that families with children do not get equal use and benefit from the benefit of the housing. Rules targeting or specifically directed at children are likely problematic. I'll go over that with some examples in a minute. No protected classes for potential claims. Know what's prohibited. And I talked to you earlier, discriminatory conduct. There's two types of discriminatory conduct. Disparate treatment, treating other people differently because of their protected class status, or disparate impact, facially neutral rule within its application has a harsher impact on people of a protected class than others. Let's go to the next slide. Avoid unintentional rule violations. Adult swim hours. I watched a guy named Chris Blankart come to Spokane 25 years ago, I guess. And Chris is a power lawyer out of LA that sues people across the United States for housing discrimination. One of the things Chris said that left me in awe was that every time he went to a new city to sue a landlord for housing discrimination, he would whip out the phone book. This is how old this is. He would look at apartment complexes in the area, and then he would try to find apartment complexes with pools, and then he would visit the apartment complex to try to find a pool that had an adult swim hour, and then he would sue them for familial status discrimination. He made the comment in that presentation, he didn't care if the case had $1 of damages, that's all he needed. He didn't have to have any real impact on the tenant as an aggrieved litigant because he would get attorney fees and costs even if there was only $1 of damages. So it's not that somebody's really been harmed in some of these lawyers' minds. Another unintentional violation is a teen curfew. Well, let me digress. So you can't have an adult swim hour, but you can have lap swim hours. You can have it so that the pool is closed from 12 to 1 for lap swimming. All right. That's not an adult swim hour. That's lap swimming. Anybody can do it if they swim in laps. You can't have a teen curfew because it's against people of a specific class and age and families. But you can have rules like no loitering in common areas after 9 that apply to everybody. You cannot have a rule that says children are not allowed to leave bicycles, toys, and skateboards on your sidewalks. But you can have a rule that says tenants are not allowed to leave any personal property on sidewalks, common areas, or patios. So if the rule applies to everybody, it's probably okay. If the rule applies to a particular tenant, it's probably not. So think about that stuff. Create clear, comprehensive, and written neutral rules. Address conduct, not character. Tenant rules should address what will happen when the violations occur. Address serious violations which endanger others, drugs, assaults, destruction of property. Address harassment. Address belligerent conduct. It is absolutely critical that your lease and rules have a broad covenant addressing a wide latitude of conduct issues. And I have some really, really broad lease covenants and rules that I have clients implement that talk about just about any type of conduct that you can dream of, including false reporting and making comments that would incite public interest or would cause a undue public excitement. So you want to have just really, really broad conduct policy rules to be able to guard against the wide range of different conduct issues that we see in multifamily properties. Address repeated minor violations as well as material major violations. Consider policies of progressive discipline, which means that you might attempt to gain compliance with the rules before you try to terminate the tenancy. Systems of lease violation warnings and opportunity to cure are a good thing. So in most of my cases, unless the tenant's engaged in criminal activity like an assault or arson, that type of thing, I'm typically using comply or vacate notices before I use a notice to quit or a notice to terminate tenancy. I want to be able to show the judge we tried to gain compliance and that we were forced to terminate the tenancy because we had no other reasonable recourse. Because I know that every time I go to court, the tenant advocates and the tenant are going to look sympathetic to the judge, and I've got to get past that hurdle to make the judge understand exactly why we're doing what we are doing in this situation. Rules must be adequately communicated to the tenant, legible leases and rules. I had a client years ago that was so cheap that he had one lease and he had photocopied it like 2 million times and then photocopied the photocopies, and his lease was largely illegible at that point. And I think in his mind that was good because he could say the lease said anything he wanted, but that's not how it works in court, folks. Most of the time, any problems with the document are going to be resolved to the satisfaction of the tenant, and any ambiguities in the document are usually resolved adverse to the drafter. That's actually a rule of construction and courts interpreting documents, which is any ambiguity is construed against the drafter. So if the document's not clear, it really goes against you, not in your favor. Use legible leases and rules. The court's looking for that to see, did the tenant understand what the rules and obligations are? Translation services may be necessary in some cases. So you may have to translate documents or provide interpretation services for meetings. So just be sensitive, especially if you're in a subsidized housing complex. Let's go to the next slide, which is enforcing.
Okay.
Go ahead.
Okay, and Eric, I just wanted to point out one other example that came up in a presentation was part of last Friday, and that is for a tenant that had broken her hip and needed to use the on-site pool for water therapy every day per doctor's instructions, and she needed help getting in and out of the pool, and the folks from her church had organized a group of volunteers, but the property manager told her she couldn't have guests over on the weekend to use the pool, so denied the accommodation, and you can kind of assume or kind of guess what happened next.
Well, that's a reasonable accommodation request to alter their guest policy.
Exactly.
And should have been interpreted like that. And that's a great segue into the concept that not all reasonable accommodation requests are obvious. Sometimes you have to kind of read between the lines to understand reasonable accommodation requests that are latent and not necessarily obvious. At the same time, the law says you're not to make the request for the tenant. So it's a dichotomy of interests, and you've got a little bit of a dilemma there in some of these situations. But I would err on the side of trying to interpret the requests of tenants liberally. And if the tenant makes these, one of the things we haven't talked about quite yet that we will is reasonable accommodations and the form of the accommodation. And the tenants aren't required to use any type of form letter that you have to make a reasonable accommodation request. They can make that reasonable accommodation request verbally or through any other means they want to. It can be in a long-winded letter. I hate the ones that read in a circle where I have to keep rotating the paper, but I get those. I get a lot of one paragraph, 3-page letters that are very difficult to read. And I have to make myself be diligent and read those documents because I never know when they're going to include some sort of latent request for accommodation that would otherwise be interpreted as gibberish or something. So a lot of ways for these.
Absolutely.
Next section is.
Do we have a quick time for, Eric, do we have time for a quick poll?
Sure.
Okay. We'll try another one here. Let's see if I can get our next poll. And it looks like that's not going to happen. So take it away. Okay,
let's go to the next slide. So enforcing rules in a non-discriminatory manner. And we had a comment after the last presentation that one of the audience members would have liked more information for maintenance personnel and for their on-site managers. And my retort is listen up. So in enforcing rules in a non-discriminatory manner, some of the tools that you have, as I keep saying, your documentation. And it starts with activity logs. Your on-site manager should have 2 activity logs. One, there should be a general activity log that relates to the property as a whole. Number 2, there should be a specific activity log for every tenant file. The activity log should memorialize any events on the property that seem strange or unusual with a summary of who, what, when, where, how, and why. Include all that information in your log just briefly. Understand that your activity logs are discoverables, which means that if you write something inappropriate in that activity log, it may be flashed up on a screen like this in a jury trial later on to show that you are discriminatory in your animus and mindset. So on your best behavior, use activity logs. Record detailed statements and summaries of events when things are unusual. One of the things I had come up that shocked me the other day, and I kind of think fits into this, is we had a property and we have just relocated a tenant to this property from another unit that she absolutely trashed. The tenant has some capacity issues, in my opinion. The tenant is living in a multifamily building alone, and I believe she needs support services. It appears the tenant's sister, who lives on the other side of the country, is a lawyer and is trying to save money by having her sister live alone autonomously and not without any supportive services. And I don't think the sister appreciates how bad the tenant is with respect to her diminished capacity. So we relocated her to another unit. And then yesterday I got a picture of the unit bathroom completely trashed, even though she's only been in this unit for 2 weeks. She has a cat litter box underneath her sink. There's cat litter all over the bathroom, and her toilet's clogged because she's been flushing cat litter, animal fecal matter, and feminine products down the toilet. And the maintenance crew took some pictures of the cat litter box in the trashed bathroom. But when I asked them for photographs of the foreign material that was flushed down the toilet, they told me that they had not preserved that information. They had just thrown it away. It reminded me of a case years ago where I had a client call me up and said that they watched a tenant throw some garbage away. They went and looked at the garbage. They went through the garbage. They found intravenous drug riggings, and they wanted to evict the tenant for unlawful drug activity. And I asked them if they had saved the drug riggings, and they said, no, we threw it back in the garbage. Just like my clients in this recent case disposed of the foreign material taken out of the toilet and didn't take any photographs to memorialize and preserve the evidence. It's all about the documents. It's all about the evidence. If you want training for your managerial staff and maintenance staff, it's preserve any evidence that would exculpate you from fair housing liability based on discriminatory intent or discriminatory practices, which means to say that I can evict a tenant that has mental health issues if she is flushing feminine products and cat litter down the toilet, as long as I have good evidence of that. But it's all about discovering, investigating, and documenting rule violations. It's all about requesting third-party verification of offenses. So when somebody complains about conduct, You write down what they said, when they said it, and who said it. And then you ask them to provide a third-party verification of that and a statement for that. And then you preserve the evidence. You write down when the evidence was received. If it's a photograph, who took the evidence, who took the photos, when they were taken. And you keep all this documentation. This is your exculpatory evidence if you get sued for housing discrimination. Issue notices of lease violation and avoid in accordance with your state law. So when you issue a notice, if a tenant's engaging in derelict conduct, it is really incumbent upon you to give the tenant a notice to comply or vacate under 6-303. You have to tell the tenant what they're doing, why it's a violation of tenant duties, cite to the lease terms and rules they've offended, cite to any statutes they've offended, and tell them that they have to comply with their tenant duties or vacate. It's really important. Make sure you cite all written policies or rules when you give these notices. Be specific in describing the conduct that was engaged in by the tenant. Use factual summaries, dates, times. I work against tenant advocacy groups all the time, and one of the common theories that they have in defending cases I bring is that the notices we've issued lack particularity or lack specificity, and the tenant didn't know what they had done that offended the tenant duties. So you got to be really, really careful in how you build up these cases and how you present the notices, and that the notices are completed properly to describe all the events that the tenant engaged in facts, as well as all the covenants of the lease or rules that were offended. When the materials talk about avoiding electronic means of communication with tenants, what I'm talking about is I like landlords to communicate formally with tenants. I don't like my landlords to communicate with tenants by text messaging or by email. I don't like that, and I don't want you to use those methods of communication except for real emergencies. And I don't want you to allow tenants to open the door to communicate in those media except for in emergencies. I had a case a couple of years ago where a tenant made 37 repair requests in the first 2 weeks of tenancy. Almost all those requests were by electronic media. Most of them were at 11 at night or 2 a.m. in the morning. And they essentially drove the management company crazy by making all these spurious requests all the time. And they created a presumption of retaliation because they continue to make the requests so frequently. So I think that you can avoid those dynamics by not providing your cell phones except for emergency purposes, not providing emails as a means for communication except for emergency purposes. Uniformly apply all policies to all offending parties. Enforce rules equally to all tenants. Avoid disparate treatment and selective enforcement. And this goes to why you want your managing agents to be friendly, not friends with tenants. I do not want my manager to have poker night where they drink and have smokes or coffee with all the tenants. What happens is they create friendships with some tenants and they alienate relationships with others. It's just not a good thing. I have a saying, don't eat where you poop or poop where you eat. And this is one of those things. Your managing agents should have friends off-site, not on-site. You're getting the toilet too close to the kitchen. Understand the need to grant reasonable accommodations, which is bend your policies in certain situations. So we may issue a notice to a tenant for a violation of tenant duties. Let's go back to Eric Kingston's hypothetical with the guests. So you give a notice to the tenant to comply or vacate for a violation of the guest policy. The tenant comes back and says, hey, I'd like a reasonable accommodation. I have mobility issues. I need to be doing some rehabilitation in the pool. I need you to grant me a reasonable accommodation to alter your guest policy so I can have some of my guests assist me in and out of the pool to do rehabilitation. Well, you would then need to evaluate whether or not the tenant was able to substantiate their disability status and the nexus or need between their disability status and the accommodation requested, and then you may need to grant that accommodation. But that's an example of how a reasonable accommodation would work. You need to reconcile, follow lease, federal, state, municipal rules and regulations through policy enforcement. So you'll see situations from time to time where an insurance adjuster or insurance agent will contact you and say, hey, I heard you had a tenant that has a pit bull your insurance carrier classifies pit bulls as a dangerous breed. You have a tenant that's asking for a reasonable accommodation of their animal that's a pit bull to allow that animal to bypass your no pet policy and be an assistance animal. So in a situation like that, one, I would challenge the insurance person to actually provide me a copy of the policy, because most of the big time insurance companies have already been sued for housing discrimination, and most of them do not have those type of dangerous breed policies. What I frequently see is local insurance agents trying to further those policies, even though they're non-existent in the master policy. So that's one issue. If it was an issue with respect to the number of animals allowed in a municipality based on an ordinance that had a kennel restriction or something along those lines, then if the tenant was able to provide verification of disability status, provide third-party verification that they needed X number of animals for X disability or X different disabilities. If I had a municipal ordinance that precluded me from allowing that accommodation, then I would respond in writing, memorializing what the request was and stating that I'd be prepared to grant the request, but for the fact that the city has a municipal ordinance that restricts that type of breed or that number of animals. And that would be a way for me to shift the liability in that matter away from my client and to whoever else it was that was furthering the policy that would prevent the accommodation. And then if that policy was unyielding and unwilling to change their policy for accommodation purposes, then I would go ahead and then probably not grant the accommodation or continue to say that the accommodation can't be granted because of the municipality's stance. But I try to distance myself from the municipality. I saw a question on short-term leasing. Eric, did you want to read that?
So what if you have a tenant that has a short-term memory due to either a mental disability or because of medication? The tenant can't remember to follow the rules, for example, smoking at least 15 feet away from the building. What if you have you issued several lease violations? Can you move to issue a comply or vacate? Or do you have to grant a reasonable accommodation based on the memory issue? I'm assuming there has to be a reasonable accommodation request before you can grant one.
Well, I feel like, Eric, that's a red herring, because I just had a request for a reasonable accommodation to smoke by a fence the other day. And I laughed it off saying, okay, get a third-party verifier to say that you need to smoke by the fence and we'll let you smoke there instead of in the smoking lounge. I knew damn good and well that no doctor's going to tell somebody that that smoking's good for them and they need to smoke anywhere on the property. So that ain't going to happen.
I have cases where if somebody does have a short-term memory issue that's kind of a verified disability by a third-party provider, they might request a reasonable accommodation that involves reminding them, say, like right when it's time to pay rent, or there might have some other requests that that accommodate that particular disability. So I don't know. I mean, I'm sure there are probably stories like this.
Sure, you're getting pretty close to a fundamental alteration of the business policy. It's not the manager's duty to be, the personal caretaker of the tenant. And all these cases are going to be evaluated on a fact-specific basis. So it's all case by case, like Eric Kingston said. I can see where it might come in, but I can also see where it might not be allowed. And I think you just have to look at the facts. If the person's asking you to forego enforcement of the rule because they can't remember not to smoke, I don't think that would work. If the person was asking for some other type of policy to prompt them to do something that wasn't too hard for the manager, then maybe that would work. Next slide. Accommodations are requested for an exception to a housing provider's rule, policy, or practice. The individual with disability must establish two things. Accommodation is necessary because of the disability, and the accommodation is necessary to access, maintain, or have full use or enjoyment of the housing. I would frame this better as they have to prove that they're a person that suffers from a disability, and then two, the accommodation is necessary for them to live as they would otherwise without the disability. So there has to be disability status and then nexus between the request and the disability. You cannot ask for the nature or extent of the disability or inquire into medical records. And I would really caution you against having any kind of query dialogue with the third-party provider, especially if it's a licensed healthcare provider. Next slide. Housing providers can require an individual to provide a verification letter from a third-party provider. Okay. A tenant is required to provide proof of disability status. Okay. That can come in a lot of different ways. If you regard the person as disabled, then that would work. If the disability is obvious or apparent, then you are not allowed to ask for verification of disability status. If the disability status is not obvious and is not apparent, then you can ask for third-party verification of disability status. You can ask for the verification to be made by a qualified professional. The HUD guidance of FHEO 2020-01 talks about licensed healthcare providers being the third-party verifier. I can tell you the case law is much more liberal. And the case law would suggest that any person in the know that is familiar with the disabled tenant can make a request for reasonable accommodation or potentially verify the same. I've seen verifications of reasonable accommodation requests from social workers, priests, and a lot of other folks. So be careful. It's not that you can say, oh, you have to be a medical doctor to verify a reasonable accommodation, either disability or nexus. Has to provide they are disabled and the disability makes the requested accommodations necessary. Housing provider cannot require a release of medical records. You're on a slippery slope if you're trying to talk to the doctors to flush out why this accommodation is not necessary. Next slide. Develop a written accommodation request procedure. Provide fair housing compliant accommodation request and verification forms. These should be very simple, generic forms. Designate an experienced individual with your company to oversee the accommodation request process and make determinations. Make sure this experienced individual has a wealth of fair housing training. Make sure all your staff have fair housing training. Incorporate an interactive process in accommodation review and response. Essentially, you cannot deny a request for reasonable accommodation unless there's an interactive dialogue between you and the requesting party. So if I'm looking at a reasonable accommodation that I think is out there and is a real stretch, the first thing I'm going to do is request a meeting with the tenant or the tenant advocate to talk about what's being requested. And I'm going to explore a lot of facts in that request. Why are we doing this? What's necessary? I'm not going to ask about the nature, extent of the disability, but I'm going to want to understand what's being requested in further detail. And then I'm going to evaluate, are there any alternative approaches that would be less cumbersome or less onerous on the management company going forward that would still accomplish what the tenant's trying to accomplish. Let's look at the next slide. Tenants are responsible for requesting any accommodation from their landlord, but the landlord cannot insist on using a specific form. Requests may be made verbally. So if I have a tenant that's making a verbal request for accommodation, I am going to have my client write a letter to the tenant that is going to essentially rephrase and restate what's being requested and that it's being requested as a reasonable accommodation. I'm going to do this essentially for the benefit of the tenant who's made a verbal request for accommodation and isn't using a form, so that I memorialize there's been a request for reasonable accommodation or a request for reasonable modification. Landlords may ask for verification that the request is disability related or necessary for the treatment for the tenant by a qualified third-party professional. So I have form letters that say, I received your request for this. We believe you were requesting a reasonable accommodation and the terms and conditions of your lease and rules. We believe that you're asking for this rule to be waived or changed, modified. And then I'm going to say, please provide third-party verification of your disability status. Please provide third-party verification of nexus from a qualified third-party provider. The HUD guidance memo, FHEO 2020-01, has two parts to it. The first part of the document talks about how landlords evaluate reasonable accommodation requests. The second part of the document is to be provided to tenants, and it provides tenants and their third-party providers with information about how to verify a reasonable accommodation request. FHEO 2020-01 is really all about assistance and service animals, but it goes on to say that its concepts and principles should be applied across the board to other types of reasonable accommodations. And then the final thing you need to know is that FHEO 2020-01 did not go through all the rule promulgation process fully, so it's still being vetted by HUD, but it's the most current guidance. The HUD laws would tell you that you really have to go back all the way to 2013 to the last HUD guidance for the definitive law. But I think 2020-01 is a good document for you to be working through right now as a current HUD position until the Biden administration potentially changes it. If the landlord wants to if a structural modification of a dwelling is required, the tenant is ordinarily responsible for paying for it in the market rate context. In the affordable and subsidized housing context, the landlord will have to pay for most modifications unless it constitutes an undue alteration of their policy or an undue financial burden. And you're going to have to open up your entire books to prove that undue financial burden. So that's not a great fallback for a housing provider, even a nonprofit. If the landlord wants the dwelling to convert it back to its original state, after the tenant moves out, the tenant may be required to do so. In some situations, the tenant may be required to fund an escrow account for money to restore the dwelling back to its pre-modification situation. That's not going to be required in all situations, but it might be required in some situations. If the tenant had you enhance the size of all the interior door thresholds to accommodate a wheelchair, then the court would not require that tenant to restore the thresholds to their prior dimensions, notwithstanding the modification. If the tenant had grab bars put up in a bathroom, the HUD probably wouldn't require the tenant to pay to have the grab bars taken out after they vacate, because they can still benefit other people. But there might be some situations where you have a ramp or something else that the housing provider may request to be removed after the tenant vacates. And the market rate context may have to be shouldering the cost of restoration in those situations.
And Eric, I think the other thing I would point out is in one of those cases where you've got essentially features that are kind of built in that creates more accessibility, that expands the market for that unit. And so maybe think about that aspect of it, where a certain percentage of the population in Idaho either has a mobility impairment or has a friend or family member with one, and they're going to be searching for units that have those features. So that's part of your market.
And as we said earlier, Eric Kingston, disability is one of the areas where you can advertise a preference. So unlike many of the other areas, you could say mobility-friendly housing or accessible housing, and it might, as you said, increase the scope of your available clientele. Okay, let's go to the next slide.
Got it.
Okay, we've covered most of this. I just got through telling you the housing provider must grant the accommodation request unless it would impose an undue financial or administrative burden, or granting the request would fundamentally alter the nature of the landlord's business practices and policies. An example of that would be a tenant with a mobility impairment and an assistance animal that is challenged to pick up animal waste. The tenant asks for your on-site managers to remove all the animal waste. You might come back and say that we're not prepared to do that. It's too big of undue administrative burden, fundamentally altering our policies. So that's just an example of one of those ways you might be able to deny it. It's better for a housing provider to suggest alternative accommodations or modifications than just a carte blanche denial of a request for accommodation or modification. And as I said earlier, there must be an interactive dialogue between the landlord and the tenant to deny an accommodation or a modification request. Next slide. Reasonable modifications. Private housing providers must allow an individual with disability to make structural changes so that the individual has full use of his or her residence. Private housing providers can require the individual with the disability to pay for the cost of modification. Publicly funded or subsidized housing providers may be obligated to pay for reasonable modification costs. Housing providers have a right to request modifications be done competently with a permit if the local jurisdiction requires a permit. Kind of have to look at the job. Does it require a professional or can it be done by somebody without a license and bond? Landlords can require tenants to remove modifications after the tenancy. Landlords can require the tenant to pay for the cost of restoration of the unit in its original condition, subject to the limitations we talked about. Next slide, individuals who associate with individuals with disabilities. Guests who have service companion animals must be allowed to bring their animal onto the property when they visit. Housing provider cannot deny a mother housing because of her child is disabled, regardless of whether the child with the disability would be living with her. Talk about protecting against discrimination. Develop internal policies and protocols addressing advertising, tenant screening, lease up, work orders, inspections, rule enforcement, claim management. So you need to have written policies for all these aspects of your portfolio and operations. Educate and train. Landlord tenant training is not the same as fair housing training. I do both. I conduct both. They're very different. One does not supplant the other. Understand limited English proficiency and language assessment plans. So if you have a significant concentration of a foreign national origin in your locale that speak another language as their first language, then you better get on board. And I would not wait to start doing these things. Foster an environment of inclusion. Include non-discrimination posters in your offices. I have those. Include written non-discrimination statements in your documents. Auditing, internal audits for performance. If you think you have a bad actor at a property, do some internal auditing, use outside agencies, set the people up to see how they react with the tester and see if in fact they are engaging in discrimination. Understand that if you have an agent that's discriminating and you allow this agent to do that, that agent has apparent authority to bind you and create liability. So it's not enough that you didn't champion what this person was doing. You have to go above and beyond that and show that, stop this type of thing from happening. Intent is not always part of the equation here, folks. Let's go to the next slide. Make fair housing part of the hiring process. Interview prospective employees about fair housing knowledge and experience. Determine training necessary for new hires, including volunteers and temporary staff. Include fair housing policy statement and employee hiring packets. So this is all just furthering this whole inclusion idea and concept from the get-go. Training, train early and often, train all staff, in-house training, regular staff training, outside training, new hires train within 30 days, and update your fair housing training annually. I want to get to some miscellaneous points, which are monitor and review all your policies and procedures and practices. It's a good time for you to go back and look and see, now that you've had this exposure, do we have some policies or practices here that might get us in hot water? Implement good, thorough record keeping, inquiries, applications, manager logs, rule violations, disciplinary matters, and accommodation requests. Don't be afraid to ask for help. You've got a lot of resources around you. HUD, Intermountain Fair Housing Council, David Penny, myself, Eric Kingston. Last section, dealing with discovered discrimination. I think this is really important for you folks. If you find discrimination in your property, first thing to do is reach out to your HR department and your employment attorneys and let them know what you found. Don't immediately fire the manager. The manager who is allegedly discriminating may be your only witness if you're sued. So it's important that we preserve the manager's testimony. Don't just assume that everything that's being alleged is accurate. Consider preserving the testimony of necessary witnesses, even if they contributed to or alleged to the discriminatory conduct. So you might want to take a preservation deposition of the manager. When you respond to claims from HUD or the Human Rights Commission or a private litigant, be professional, clarify the facts. I win and lose fair housing cases on the facts, not the law. Provide legal briefing only on specific narrow issues that are uncommon. The investigators typically know the law better than you or your lawyer. Provide documentation supporting proper conduct. This is your maintenance logs. This is your evidence of tenant-caused damages. This is the third-party written complaints from neighbors about the tenant's conduct that motivated you to issue notices to the tenant that are now being used to accuse you of discrimination. So keep that exculpatory evidence that you've garnered and gathered through this whole process. Invite conciliation. When a case goes to HUD or the Human Rights Commission for housing discrimination, the HUD or Human Rights Commission investigator is investigating the case, and they're wearing a hat as an investigator. They're also wearing another hat as a conciliator or somebody that can settle the case. You want to settle these cases before HUD makes a good cause determination. And if HUD makes a good cause determination that housing discrimination has occurred, then you're going to be really, really challenged to settle that case for any kind of nominal value because the tenant thinks they've won the lottery at that point. So really important to try to conciliate these cases before a cause finding and, be professional. I've had cases where I've watched a lawyer for a landlord yell at the HUD or Human Rights Commission investigators, tell them that they're incompetent, tell them that they're going to get fired, tell them that they don't know what they're doing. That doesn't do anybody any good. This person's usually the one that's dictating your fate. And they've heard this type of rhetoric before. It's not going to make them back down. But you always want to try to conciliate these cases.
Eric, I've got a quick question.
Sure.
Tiana asked about, a guest of one of the tenants who requires an assistance animal or companion animal. And I'm assuming, service animals would be included in that too. And I'm assuming also this is just a one-time, like somebody visiting. So any thoughts on that? And I know we're over time, so.
My thoughts on that is it's a real sticky wicket. If the disability status was apparent or obvious, then I definitely would not police that kind of conduct at all. If it's not apparent or obvious, then you may issue a comply or vacate notice to the tenant for having an unauthorized pet on the property. I'm not a big fan of these leases that have a no-fault rule that imposes a fee of $500 if any animals in the property for any duration of time. And if you have that type of fee or fine and you impose it in this scenario, you are just you're kicking the hive and you're going to get a violent response more often than not. So got to be careful. I think these things are fact specific, and I would like to use the basis that we are out of time to answer that one any further.
Okay, and then since we're out of time, we've still got we got about 120 plus participants left who've weathered this whole thing. Thanks for hanging in there. And I put a note in the chat that next week's session is we're kind of labeling that an advanced session, and the reason being that these first two intermediate sections are really pretty much the same information. The only difference is the questions we get. Next week's session is really a chance for you to ask questions from two different fair housing experts, Eric Stephen and Dave Penny. So those of you who have questions that you didn't get to ask today, that's an opportunity for you to do so. And we should have lots of great conversations next week. I'm guessing we'll have more than one question about assistance animals next week, because we always do. Eric, thanks again for your time and expertise and experience, and perspective on this. It's always great to hear from somebody who's been in the trenches for this long. And thanks to all the participants for showing up today. Like we said earlier, this session has been recorded. As soon as we can get that recording uploaded to the web, we will post a link to that on the fairhousingforum.org site, and you should find that in the session, the 2021 spring session link there. So everybody have a great week and weekend, and don't get into trouble.
Thanks everybody.